Welcome back to the Law and Crime Network. Well, let me tell you that the Parkland school shooter trial will resume tomorrow with the start of the state's rebuttal case. And we've been waiting for that, as you know, as the defense had unexpectedly rested a while back after calling less than half of the witnesses that they had put on their witness list. Well, there was a motion where the state asked now to have certain evidence heard by the jury that has been sitting waiting for more evidence to be presented. That is defendant's use of swastikas and also his use of racial slurs. The judge ultimately ruled that some of this evidence would be admissible, but had some limitations on it, and also limited the social media posts that the jury could hear on the rebuttal case. Because remember, the rebuttal case is to disprove whatever the mitigating factors the defense had advanced. Well, Judge Scherer is also allowing the state's psychiatrist, Dr. Ferguson, to also testify for the defense in a limited manner. So I'd like to take you back to some of those arguments regarding this motion. Why don't we listen? It was argued for the prosecution by Jeff Marcus.
A motion to strike a witness, it's really, they're asking for a Richardson hearing. It's premature. They're going to depose him, so they'll have an opportunity to depose him. The defense, the state has listed him, so, and the argument about the psychological records, that it never had come up before that the defense was going to use violent video games as an unhealthy obsession by their own admission, as a mitigating circumstance, or that he can't tell the difference from reality and a violent or a game itself. So it clearly came up during the trial. The psychological records that were given to him were just so that he knows what the defendant was diagnosed with as a child. These are psychological records from the school. So it's just a record so he knows what he was diagnosed. As to whether or not that'll make a difference as to his opinion, the state anticipates that his opinion is that there's no causal relationship between violent video games and killing. And that will be about the extent of his testimony, which the defense will have ample opportunity to take his deposition.
Okay, this is very interesting. Maria Pereira, let me go to you first, because as we know that the defense can advance mitigating factors and the jury can accept them or decline them. And then there's a rebuttal case, and usually rebuttal cases are limited in Florida, but here the judge is allowing one and is allowing the rebuttal case to go forward. Do you think that it's fair that if the statutory scheme is aggravating versus mitigating, that the judge allowed this evidence to go forward?
I think it's fair because they put on witnesses to testify that he's suffering from effects of fetal alcohol syndrome. So the state should be allowed to put their witness back on to testify that it was more antisocial behavior and nothing related to a neurological mental development. I think the judge made a proper ruling, and although all the defense wants to do is to mitigate, it's the prosecutor's job to irate, and they should be allowed to proceed and put on this evidence in their rebuttal case.
Judge Satoli, that leads me to the question that really is the main focus of this, is that if the murders here and the killing of 17 people, 14 young adults and 3 teachers, faculty members, and the manner which was done, turning Valentine's Day, as I always say, a day of love into a day of hate and brutality and bloodshed, isn't that enough to get the death penalty here? If indeed there's going to be a juror or two who is going to say, hey, no, I'd rather him spend the life behind bars, that it's going to happen because they just want it to happen, they think that the death penalty may be too good for him?
I certainly think that's a really strong possibility, and I think it's something that the defense should argue. I think it's a really a keen point. I think that what the prosecution is going to do is bring in some of these other facts and that weren't allowed in their case in chief because they're too prejudicial, but they are appropriate in a rebuttal case. So I think we're going to have a very strong arguments on both sides here. This is a heinous case, so there's no two ways about it.
Yeah, it certainly is whenever you're dealing with the death of children, especially. Not that all deaths aren't equal, but the death of children is something that just tears at our heartstrings. Okay, so why don't we listen to the Assistant Public Defender, Tamara Curtis, argue the other side of the case. Let's listen.
With respect to the motion to strike Dr. Ferguson, there's a big difference between having a neighbor come in and talk about him playing violent video games, and a principal and a teacher who is not a psychologist, who's not an expert, who said in a record that the state has been in possession of for months and months, and yet didn't find it compelling to hire and list this witness, that I sometimes wondered if he knew the difference between violent video games and reality. There was no defense expert, and not even these other witnesses, who were simply lay witnesses that just observed that he watched violent video games. No defense expert said that this offense was in any way committed but because he played violent video games. So that is not rebuttal to anything that the defense has said. And when I said a moment ago that this list may not be exhaustive, and Mr. Marcus's response is we have to guess, they don't have to guess. I said it was not exhaustive because this is based on our 3.202 notice and my recollection of what we presented during the trial. It's not that they have to guess. They were there. Everything has come out from the defense. The defense rested its case. There isn't going to be any more mitigation presented in the defendant's case. So they don't have to guess. It's just I may not have included every single thing that came out in this motion.
But Joseph Tolley, the point she makes, I guess, on the social media aspects especially, and also the psychologist, let's talk about separately. Let's talk about the psychologist first, is that, look, they could have called this doctor. They've had, they did testing of him. They did all sorts of things. Then the defense puts on their case dealing with their doctors, and now they're going to call this doctor and say, well, you defense doctors, you weren't, you weren't accurate, even though the state knew that in the beginning. So that it's the order of presentation, she argues, that indeed the statute was not set forth to have the mitigating factors attacked except in cross-examination. Your thoughts?
Sure. It boils down to an apples and oranges argument. The public defender there, the defense for the accused, is saying, hey, look, Judge, this evidence wasn't admitted in the prosecution's case in chief for a reason. And now because we put some of our experts on, but our lay witnesses on to speak in lay testimony about X, Y, and Z. Now the prosecution is coming in with their experts, with their psychologists. So, we put on apples, and now you're letting the prosecution put on oranges, and that's not fair.
Yeah, and Marie Pereira, in terms of the social media posts, how does the prosecution, if they're trying to rebut mitigating factors, say that, well, this social media post wasn't done for fetal alcohol syndrome because of it, it was done to hatred? How do you determine whether the social media post is because somebody has an injured brain or a broken brain right from birth or pre-birth versus somebody has an antisocial personality? And can there be two? Can you have an antisocial personality because you have fetal alcohol syndrome?
I think the prosecution is arguing a point that doesn't need to be argued. Just because you can make a motion doesn't mean you have to. I don't see what forcing the judge to allow the fact that he watched and engaged in violent video games or social media posts, how is that going to tip the scale at this point? I think to an ad nauseum, they presented their case of aggravating factors, and this is not going to make a difference. So they need to just really crunch their rebuttal and not bore the jurors, because they've been sitting in that box for a very long time, and they don't need to hear anything that's not absolutely necessary and wasn't presented in the state's case before. So I think he should just let it go and stop arguing about little things that could in fact hurt him at the end of the day.
Yeah, and as a matter of fact, it could hurt because you're giving the defense the opportunity to have more on an appeal. And if it's one thing about death penalty cases, they go on for appeal a long time, over and over again, and every little detail becomes an issue. And as Bob Bianchi always says, what Marie just said, just because you can doesn't mean you should. Stay with us. On the other side, we'll be talking about another horrendous case, the killing of the Pike County massacres in Ohio. Stay with us.